number 22-50073, Ho Wan Kwok.
Okay, good afternoon. Court is, we just had another hearing that ran long, so I'm sorry to keep everyone waiting. We could have appearances for the record, starting with the debtor's counsel, please.
Good afternoon. William Baldinger Brown running for the debtor.
Good afternoon. Counsel for Pax.
Good afternoon, Your Honor. It's Peter Friedman from Albany and Myers. I see Mr. Sarnoff as well and Mr. Burney.
Good afternoon to all of you.
Good afternoon, Your Honor.
Counsel for the Creditors Committee.
Good afternoon, Your Honor. Earl Goldman, Bowman and Conley, Counsel for the Creditors Committee.
Good afternoon. Counsel for Ruma and the other creditors.
Good afternoon, Your Honor. Kristen Mayhew, McElroy, Deutsch, Mulvaney, and Carpenter on behalf of creditors Ruma, Zhang Wu, and Wee Kim Mei.
Good afternoon. And counsel for the U.S. trustee.
Good afternoon, Your Honor. Holly Claiborne for the U.S. trustee.
Good afternoon. Do we anticipate anyone else? Oh, I'm sorry, Attorney Woolman. Go ahead. I didn't see you.
Good afternoon, Your Honor. Jay Woolman of Randaz Legal Group for creditor Logan Chang.
Good afternoon. I think that I've taken everyone's appearances. Is that correct? Okay. All right. So today's hearing was a hearing on an application to appoint trustee, an application for order approving the Chapter 11 trustee appointment, which was ECF number 499, and a motion to expedite the hearing, which was filed on Thursday, June 30, Thursday, June 30, 2022. The order granting the motion to expedite entered, setting a hearing for today at 3:30 p.m. It's 3:58, as I said. I'm sorry, our 3 o'clock hearing ran later than we thought it might. But in any event, the motion to expedite was granted because the court wasn't sure why the United States Trustee's Office had filed an application to appoint a trustee and asking for an order approving the appointment of a trustee. And then today, there was a withdrawal filed by the U.S. Trustee's Office of the application. So Attorney Claiborne, I'm not sure what is happening here, but as of June 30, Mr. Whiteley, I don't know if it's Whitley or Whiteley, accepted the appointment as being a Chapter 11 trustee in documents filed on the docket of this case. He also filed an affidavit saying he was a disinterested person and therefore appeared to meet all the requirements of a trustee, and as of June 30, became the representative of this estate. And then today, a withdrawal was filed by your office, signed by you on behalf of Mr. Harrington as the U.S. trustee for this region. So I'm a little confused as to where things stand and why the U.S. trustee's office felt it even needed an order approving the appointment, because the documents say under 1104D, but 1104D doesn't come into effect when I've already ruled for the appointment of a trustee. So your office's role, I think, is what you did. You appointed a trustee. So what's the issue now? Why is this being withdrawn?
Thank you, Your Honor. The process is implemented through Rule 2007.1.
Yep.
Subsection C.
No, but that subsection doesn't come into effect unless there's a problem. 2007.1 says that an order to appoint our trustee or examiner in a Chapter 11 case, a motion for an order to appoint a trustee or an examiner and that motion was already granted, and that order entered. So 2007.1 is already taken care of. The rest of the section talks about an election of a trustee. And if there was an election of a trustee, your office would have to certify there was an election and say what the results were. And there's nothing on this docket that indicates this trustee was elected, number one. And number two, if there's some problem with regard to this trustee, then it needs to be disclosed. Is the trustee resigning? Are you removing the trustee? Has the trustee passed away? I mean, those are the three grounds under which there would be a need for a court order. So, and this trustee is still the trustee until this trustee is not. So, what is the status?
Your Honor, getting back to the interplay between Rule 2007.1, subsection C, and 1104D, the process as envisioned by the combination of that statute and that rule is that the court orders the U.S. trustee to appoint a Chapter 11 trustee, and then the U.S. trustee is to file an application that gets approved by the court, and thereafter, if that approval is obtained from the court, then the Chapter 11 trustee who's appointed, it becomes effective. So the U.S. trustee has no current candidate before the court, and there is no current Chapter 11 trustee before the court.
Well, 1104D says, if the court orders the appointment of a trustee or examiner, which I've already done in a memorandum of decision that was issued on June 15, if a trustee or examiner dies or resigns during the case or is removed under Section 324 of this title, or if the trustee fails to qualify under Section 322 of this title, then the United States trustee, after consultation with parties in interest, shall appoint, subject to the court's approval, one disinterested person other than the United States trustee to serve as a trustee or examiner as the case may be. So it already talks about the prior trustee dying or resigning or being removed. So 1104D deals with a successor trustee issue, not the original trustee. And so,
I think it's important. I apologize.
That's all right. So 2007.1 is premised on 2007.1C, approval of appointment, is premised on 1104D, which I just read, which is just addresses the issue of when the trustee or examiner dies, resigns, or is removed.
Your Honor, 1104D has three topics, as it were, that start that section. One is if the court orders the appointment of a Chapter 11 trustee or examiner. Two, if a Chapter 11 trustee or examiner dies or resigns. Or three, if a trustee fails to qualify under Section 322. So we are in the first section. If the court orders the appointment, which the court has, then you skip down to the part that says the United States trustee, after consultation with the parties in interest, shall appoint, subject to the court's approval, one disinterested person to serve as the Chapter 11 trustee.
But we don't approve the appointment of trustees in Chapter 7 cases, in Chapter 13 cases, or in Chapter 11 cases. We've never entered orders approving the appointment of a trustee unless there was an election or a dispute with regard to the trustee. So, but that's still not answering the question. This is the trustee. How does the trustee just get to withdraw when they already said that they are accepted the appointment, and now 5 days later they don't? Where's the trustee, and why isn't the trustee here? How do you get to withdraw a trustee? We've now lost 5 days, of which somebody was supposedly the representative of this estate, and you don't have anybody else here, right? There's no successor trustee. So what is the plan?
Your Honor, currently there is no Chapter 11 trustee appointed.
Well, that's
the U.S.
not true.
trustee withdrew. Your Honor, I respectfully disagree with the court's interpretation of this section and the rule we've just been discussing. It's the U.S. trustee's viewpoint that the intersection of the rule and the section require a process that the U.S. trustee has engaged in. That process includes the notice of appointment. It includes the application to ask the court to approve the appointment. And that process also offers the opportunity for anyone to come in and have comments or criticisms or objections to the appointment, and for that process to play out. We are here today after the U.S. trustee has withdrawn the notice of appointment and has withdrawn the application to approve the appointment. And that withdrawal happened due to a late arrival of information that happened this morning with respect to a conflict search.